thank you all so much for joining me today, and hopefully this is going to be interesting and helpful for you. As you know, this is the topic. Before I start, I just say my name is Amber Turner. I'm a barrister at Rectification Chambers. I joined as a tenant in October, so I'm still quite new, but before that I completed pupillage at Radcliffe, so I have been around for just over a year now. Let's get started then. So, on the agenda today, interpretation, rectification, some procedural points to note, and then a quick mention for variation. It's not going to be the focus of this talk, I'm afraid, but if you are interested in finding out more about that, then I'd be happy to discuss it with anyone after. In terms of the structure and questions, I'm not going to be doing a Q&A at the end, just because the way the webinar works, it's not the easiest format to answer questions like that. But my email is going to be on the final slide, and there's also a Q&A box. If you want to put questions in the Q&A box and put your email address with the question, then I'll get back to you. And so any thoughts, any questions, very welcome to email me with those. So, first point, interpretation. A bit of a question for you all. What do contracts, patents and wills have in common? Unfortunately, there aren't any prizes for right answers, and I can't actually see you, so I don't know if any of you are making suggestions. But here is, well, the answer is they're all legal documents, but that's not the end of it. As private client lawyers, I'm sure you don't have much to do with patents. You probably come across contracts and probably a lot of wills. So the answer is that when it comes to interpretation, they should all be approached in the same way. So this is Lord Neuberger in Morley and Rawlings, which is this leading Supreme Court case in this area, and I'm going to come back to it quite a few times. And he says a will should be interpreted in the same way as a contract, a notice or a patent, as summarised in paragraph 19 of his judgment. In particular, section 21, which I'm also going to come back to quite a few times, shows that evidence is admissible when construing a will, and that includes the surrounding circumstances. So let's take a look at paragraph 19, because we need to know what the ordinary approach is. Well, as Lord Neuberger says, when interpreting a contract, the court is concerned to find the intention of the party or parties, and it does this by identifying the meaning of the relevant words. A, in the light of 1, the natural and ordinary meaning of those words; 2, the overall purpose of the document; 3, any other provisions of the document; 4, the facts known or assumed by the parties at the time that the document was executed; and 5, common sense. But B, ignoring subjective evidence of any party's intentions. Now you'll see that I've colour-coded some of these considerations to help us have a think about how they might apply to a will. Now first, we have the natural and ordinary meaning of the words. So we take a step back and, not thinking about anything else, on first glance, what do the words mean? We don't easily accept that people make mistakes when they choose to use particular words. So, and that's especially the case in formal documents like wills. So the natural and ordinary meaning of the words is important, but that takes us on to the next stage. So I've used the colour coding to show how this fits in. So the overall purpose of the document, other provisions within the document, and common sense have been lumped together as internal evidence from the will. Now, I can't take credit for that categorisation. That's actually from a judgment in a case called Rebracey, which is a case that I'm going to come back to again. And it's actually a very helpful judgment if you only want to read sort of 5 paragraphs of a judgment to get a sense of how interpretation and rectification works. Then I would really recommend taking a look at Rebracey. And I think it's paragraph 17 to 22. So that's the internal evidence from the will. That's what we can get just from having a look at the will. But what can we look at that's not contained in the will? These are the facts known or assumed by the parties at the time that the document was executed, and that's summarised quite nicely in what's called the armchair principle. Now, Lord Romer in Perrin and Morgan summarised the armchair principle A cardinal rule of construction is that a will should be so construed as to give effect to the intention of the testator, such intention being gathered from the language of the will, read in light of the circumstances in which the will was made. To understand the language employed, the court is entitled to use a familiar expression to sit in the testator's armchair. When seated there, however, the court is not entitled to make a fresh will for the testator merely because it strongly suspects that the testator did not mean what he has plainly said. So this is a really helpful summary, and it also gives us a bit of a warning about the limits of the armchair principle. It has to make sense in terms of the natural and ordinary meaning of the words, as well as making sense in the context as the testator said it. So what kind of facts might we be thinking about when we're talking about the armchair principle? In re Bracey, which is the case I mentioned earlier, the judge took into account the following relevant facts. The fact that the testator had been diagnosed with dementia, which would be progressive, so there was little or no realistic prospect of his having the capacity to change his will in the future. The beneficiary, Mrs. Irene Bracey, who was his wife, was herself very ill, and there was no expectation that the beneficiary would survive the testator or vice versa. So we're looking at what it says in the will, but we're also taking a step back and thinking about things such as the health of the testator and the health of the beneficiaries, which are going to affect what the testator would have intended at the relevant time. But sometimes we do depart from the ordinary approach. So the ordinary approach is the same for contracts, patents, and wills, but actually, in the case of wills, sometimes the process of interpretation goes further than it does with contracts and patents. And Lord Neuberger described this in Morley and Rawlins. And this is because of section 21, and the text of section 21 is going to be on the next slide, and we'll talk about that a bit more then. Lord Neuberger says that section 21 goes further. It indicates that if one or more of the three requirements set out in section 21 is satisfied, then direct evidence of the testator's intention is admissible in order to interpret the will in question. So a will is to be interpreted in the same way as any other document, but in addition, it's possible to assist its interpretation by reference to evidence of the testator's actual intention. And this is where it differs from the ordinary approach. So the ordinary approach is trying to get at what the testator's intention was, but we do that only by looking at the language and the surrounding circumstances, and we don't look at evidence, direct evidence of the testator's intention. So when can we look at direct evidence of intention? Well, there are three circumstances as set out in section 21 of the Administration of Justice Act 1982. This section applies to a will insofar as any part of it is meaningless, insofar as the language used in any part of it is ambiguous on the face of it, and insofar as evidence other than evidence of the testator's intention shows that language used in any part of it is ambiguous in the light of surrounding circumstances. So what do these things mean? Well, meaningless, the textbook very helpfully says that meaningless means lacks meaning. But it does more helpfully point out that that has to mean any part of it appears to be meaningless, because if it's actually meaningless, then interpretation is not going to get us any further. So, for example, if the testator has tried to leave a legacy, but they've left the amount blank, then the blank itself is meaningless. At that point, we might turn to surrounding evidence, direct evidence of the testator's intention, for example, in any previous drafts or in notes or instructions given by the testator. We might be able to fill in that blank, and we might be able to take evidence of the testator's intention and interpret it as being the blank, but that's not always the case. In the case in which there was a blank, unfortunately, there wasn't sufficient evidence for the court to fill in that gap. The second requirement is that it could be ambiguous on the face of it. Now, that's a word that has two or more meanings, and that word just has two or more meanings. The first time you read it, you think, oh, that could mean X or it could mean Y. Slightly more interestingly is ambiguous in the light of surrounding circumstances. So this could apply where a word does have a settled meaning, but in the context as it's being used, it is ambiguous. So an example is in the case of Reading and Reading. I think it's Reading and Reading, it might be Reading and Reading, which is a decision of Mrs. Justice Asplin, as she then was. In that case, the word issue had been used, and that has a fairly settled meaning, but in the context in which it had been used, it was ambiguous because of the testator's particular family dynamic, which included stepchildren and children. Now, that's not to say that whenever there are stepchildren and children, the word issue will be ambiguous, but it was in this particular case. And that's the point that keeps coming up when it comes to interpretation, is that every case turns on its own facts. So all of the things I'm saying are helpful, but they're not necessarily guiding in the particular circumstances of a case. So when one of those three conditions is met, then extrinsic evidence, including evidence of the testator's intention, may be admitted to assist in interpreting the will. So evidence that might be, as I've already said, anything that the testator said to the will drafter or any other person at the time that the will was being drafted, or what the testator wrote in notes or instructions or in earlier drafts of the will, which are also relevant. So that was very quick look through interpretation. So we've seen that there's a first stage to interpretation, which is to look at the natural and ordinary meaning of the words, and also to take into account the surrounding circumstances via the armchair principle. But at that stage, we don't look at direct evidence of intention. Then we've seen that there's a second stage, which is under section 21, where we do look at direct evidence of intention. Now, the third stage, and it is often a third stage, although it could come as a standalone claim, it's usually pleaded together with interpretation. The third stage is to look at whether the will can be rectified. Now, that will come in when there's a case where either the will has a very clear meaning, but it's not what the testator intended. And so interpretation just isn't getting you where you need to get. So how do we do rectification? Now, I can't see your faces, but hopefully none of you are looking as bored as this lady right now. But I appreciate that it might seem to be a dry question whether a particular approach is one of interpretation or rectification. And that's something that was acknowledged by Lord Neuberger and Morley and Rawlins. However, it's not just an academic issue of categorization, because there is a difference. When you're interpreting a document, then you're trying to find out the meaning that it's always had, and that's the end of it. But if it's a question of rectification, then the document as rectified has a different meaning from that which it has on its face. And in those circumstances, the court has a discretion as to whether to grant rectification. So you're not guaranteed to get rectification. There's also another important practical difference between interpretation and rectification, which is that there is a 6-month time limit for bringing a rectification claim. And we'll come back to that shortly. So the jurisdiction to rectify a will is a statutory one, and it's set out in section 20 of the Administration of Justice Act 1982. So the court must be satisfied that a will is so expressed that it fails to carry out the testator's intentions, and that failure must be in consequence of either a clerical error or a failure to understand the testator's instructions. If it's satisfied of those two things, then it may order that the will should be rectified so as to carry out the testator's intentions. As I mentioned, the 6-month time limit set out there in section 22. So the application must be brought within a period of 6 months from the date of the grant of probate or the grant of letters of administration. So what do these two situations look like? Now, the first situation is a clerical error. And Lord Neuberger and Morley and Rawlins did dedicate some time to considering what this means. He decided that it should be given a wide meaning rather than a narrow meaning. And in fact, he said that the grounds for rectification should be as wide as this section properly allows. Now, it's previously been summarised as where the drafter writes something that he intended not to write or omits something which he intended to insert. The width of this particular provision is demonstrated by Morley and Rawlins, which some of you may be aware involved a situation where a husband and wife had wills drafted, which essentially mirrored each other. However, due to a mistake, the husband was given the wife's will to sign and the wife was given the husband's will to sign. So when it came before the court, there was actually an interpretation claim, and I'll come back to that shortly, but there was a rectification claim too, and that's what succeeded. So the claimants in that case were asking for the will to be rectified so that it was the will that it should have been and not the will that was signed. Now, you may think that goes quite far for a clerical error. It's not just writing something that you didn't mean to write or omitting something that you did mean to write. It's a wholesale mistake. It's just handing the wrong thing to the wrong person. But Lord Newberger concluded that there was an error which could properly be characterised as clerical because it arose in connection with office work of a routine nature. So office work of a routine nature is now considered to give rise to clerical errors in appropriate circumstances. But there is a limit to clerical error, and Lord Newberger said that limit related to cases which would otherwise overlap with the second limb, which I'll come to now. So the limit to clerical error it can be seen by reference to where it would overlap or subsume a failure to understand the testator's instructions. Now, it goes without saying that in order to be sure that there's been a failure to understand the testator's instructions, we need to know what the testator's instructions were. So it's important that there's a clear record of what the instructions were. So this limb has a more limited scope than the first limb. Importantly, it won't apply where the drafter of the will understood the testator's instructions but used the wrong words. So where the drafter tried to carry through the testator's instructions, but failed to do that because of misunderstanding the legal effect of the words that were used. It also won't apply to a homemade will, as in a will written by the testator, because Limb B requires there to be a drafter involved who's separate from the testator themselves. So what are the limits to the remedy of rectification? Now, as I've said, Morley and Rawlins is the leading case, and that went pretty far. So what was ordered was effectively a wholesale correction, and the husband's will and the wife's will needed to be rectified because they'd been handed to the wrong person. So they could be read as though the right will had been handed to the right person. However, Lord Newberger did say that as a general proposition, there may be force in the point that the greater the extent of the correction sought, the steeper the task for a claimant seeking rectification. However, Lord Newberger could see no reason why a wholesale correction should be ruled out as a permissible exercise of the court's power to rectify. On the contrary, to impose such a restriction on the power of rectification would be unprincipled, and it would also lead to uncertainty. Now, there is a bit of a warning note on rectification, and I think this is demonstrated quite nicely by the case of Kellen Jones. Now, in that case, the drafter of the will had made a mistake as to the legal effect of words he had chosen, and therefore the conditions for rectification weren't met. Now, there had been a failure to carry out the testator's intentions, because the will didn't have the effect that the testator wanted. But that wasn't because the drafter had made a clerical error, and it wasn't because of a failure to understand instructions. In fact, when the drafter came to court, he gave evidence that he thought that the effect of the words was to carry out the testator's intentions, but unfortunately the court disagreed. In that case, rectification isn't available. And that's something to bear in mind when considering what's gone wrong. So a couple of points to note on the procedure. Interpretation. If there is any doubt about the meaning of a provision in a will, so if counsel has advised that there's some doubt, or if the beneficiaries themselves have different preferred but rational interpretations of the will, then the personal representatives are obliged to take steps to have the true meaning determined by the court. Parts 64 and 8 of the CPR apply, so the claim should be brought by Part 8 claim form. There is an alternative route under Section 48 of the Administration of Justice Act 1985, which allows the court to authorise action to be taken on the basis of an opinion from qualified counsel. That's quite a specialist procedure. I'm not going to go into detail on it, but it's worth being aware of if you are in the position of having to bring an interpretation claim or application. Rectification should be handled under Part 57 by a probate claim if it's opposed. And as I've mentioned already, there is a 6-month time limit on a rectification claim. Now, that's quite similar to the 6-month time limit for 1975 Act claims and motivated by the same desire to protect the PRs and allow them to sort of take steps to administer the estate once 6 months have passed from the grant. Finally, a quick mention for variation. So you might need to use variation when the will as interpreted doesn't achieve the desired result and rectification is not available, perhaps because there's been a failure to carry out the testator's intentions, but not for the reasons in Section 20. The issue is that you need the agreement of all the beneficiaries, and if there's any minors and unborns, or some of the beneficiaries don't have capacity for any other reason, then there might be some difficulty in achieving the desired result using this route. It's worth noting that variations can have retrospective effects for inheritance tax and capital gains tax purposes, but there are statutory provisions which need to be complied with in order to effectively use a variation for that reason. So, a bit of a whistle-stop tour, but let's just recap what we have seen today. So, the ordinary approach to interpretation is the same approach that you would take if you were interpreting a contract or a patent. And you're also looking at the armchair principle, so the facts and circumstances that were known or understood by the testator at the time that the will was made. For example, what the health of the testator was, what the health of the relevant beneficiaries was. However, at this stage of the interpretation, what I'll call the first stage, you're not looking at direct evidence of the testator's intention. We'll only start to look at direct evidence of intention if Section 21 applies. So that's if the will is meaningless or part of the will is meaningless or part of it is ambiguous. And then we can look at direct evidence of intention. Rectification comes in usually at the third stage after interpretation, and when interpretation has not got the result that's needed. And I've summed it up, and there's been a whoops, and the document needs to be rectified in order to give effect to the testator's intentions. So that brings me to the end of my talk on interpretation, rectification, and variation of wills. I hope that it's been helpful. I really appreciate everybody who has taken the time to join me today. I'm sorry again that Jonathan isn't able to make it, so there won't be anything after I've finished speaking. You're free to go whenever you choose. As I mentioned at the beginning, my email address is on this slide if you want to take a note of that. If you've got any thoughts that you'd like to share or any questions about anything that I've said today, then please do feel free to reach out by email or LinkedIn if you prefer. And yeah, all that remains to say is thank you very much for joining me, and I hope to meet some of you in person at some point in the not so distant future. Thank you very much.